Court calls case of the people versus Milton Ray.
Carville, on behalf of Mr. Ray, who's approaching the podium and will be standing to my right. Here. Mr. Ray, once you approach the podium, please state your name for the judge. Thank you, Your Honor. One more time, a little louder so the record.
Milton Ray.
Thank you, Judge. Thank you, sir. Your Honor, today's the date and time set for probable cause conference. May we approach? Thank you.
Record should reflect date of bench conference. Go ahead.
Thank you, Judge. So at this time, we are here for PCC and bond violation. At this time, Mr. Ray is going to admit the violation for positive tests.
All right. Is that correct, sir?
Yeah.
Okay, and you understand you could have a hearing on it?
A hearing?
You don't want a hearing?
What it means? It means you could have. It means you could contest it if you wanted to, but we're just going to admit the violation.
Oh, okay.
Is that what you want to do? Do you understand that?
Yeah. That's what you want to do? Okay, I'll accept the admission to the violation. Okay, what are we going to do with the case? And then,
Your Honor,
how long has he been in?
When did you get in? About a week?
Last Saturday.
So since since last Saturday, so about a week.
This past Saturday?
Yeah. So just been one Saturday. Yes, just this past Saturday.
Go ahead. What's your argument?
Your Honor, we would ask for a bond that Mr. Ray be released back on bond. We have had a discussion, and we have had discussed going forward that he needs to stay clean and have no more positive tests. He's a Marine Corps veteran, and he has he receives Social Security and does odd jobs. I would also like to note that the complaining witness in this matter is currently also in Washtenaw County Jail for 2 DV third felonies, at least one of which he is the victim on. And so we are asking that he be released on bond. One of his tests was positive for drinking, so we would accept either a sober link or a drinking tether to keep him in line on that. Nothing further.
Otherwise, what does he want to do with the case?
Well, if he stays in, we'd like to be set for exam. If he is released, we'd like to be adjourned.
Well, I'm going to sentence him on the violation to 15 days, credit 5.
Okay.
So
we'd like to be set for exam then.
Okay, that is his sentence on the violation. And then discovery is complete.
Yes, Judge. To my knowledge.
People have their witnesses available to second.
We'll do our best, Your Honor.
Preliminary examination in person, December 2nd, 2025, 9 a.m. Before Judge Barr. At this point, Bond will continue. Thank you.
Keep that up.
Court calls case of people versus Deidre Woods.
Oh, she's on the, okay. This was state your name.
Deidre Woods.
Thank you, ma'am.
You're welcome.
Things are just a mystery for you, aren't they, Miss Hacker?
Go home and start over. Judge, we are asking for an adjournment today. We are still in negotiations with the people. I'd also like to address bond, please.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. on both matters. As to bond.
As to bond, Your Honor, we're asking for a PR bond in this matter. Ms. Woods is currently dealing with a matter in circuit court. In that matter, she posted bond and she had a hold out of Wayne County. So Wayne County picked her up. And when she resolved her matter in Wayne County, they wanted to release her on a tether. But then these warrants were authorized. These warrants are just a little older than the original case. So it's not as if there was a new case that she picked up while she was in custody. So she is looking to see if we could get a PR bond on this matter, as she already has a cash bond that she's posted in one of the matters in this district, and in Washtenaw County.
What kind of case is that?
The other case is give me 1 second, Your Honor, I apologize. Malicious destruction of personal property, Judge.
Okay. Any response from the people?
Your Honor, the home invasion file is older. It's about a year and a half old from 2024. However, the case brought in the other file charge, the financial transaction device, is just a offense date from this summer. She would have been out on bond at the time that offense was committed. And with the two open cases, I think that some form of drug testing or other physical monitoring is appropriate, not opposed to the PR bond. I just think appropriate conditions are necessary.
Does she have, is on her release on the other case, is there a drug testing component to that?
I can check, Your Honor. I do not believe so.
Supposed to be a tether that I'm released to, a tether with not, of course, GPS monitoring.
And Judge, you mean
The
the
PR bond.
Washtenaw County?
Pardon? Yeah, the one in Washington.
I don't think so. And she hasn't been out to be able to.
So I guess there's that. And then the other thing is, if she's released on our cases in a way, is she then to go to Wayne County to be put on a tether?
That is correct. That's my understanding, Judge.
All right. I'm going to grant the modification. In both cases, I'm going to give her a $10,000 personal recognizance. In each case, she is also, in our cases, to be placed upon a GPS tether prior to release.
Okay.
All right. I am also going to order that she report to community corrections for 2 times per week drug testing.
Thank you.
All right. Anything further?
No, did we get a date, Your Honor?
I wrote one. So I say yes. Did you not get a date?
Your Honor, for the record, I didn't hear it.
Why do you cover? Why do you really, man? Really? You could have just left it alone. You did not need to be part of that. And I don't know why you're covering for acting. We had her going that I said it. She didn't hear it.
Thank you, Trevor. Thank you.
I don't know what's going on here. Mr. Allen, did I give a date? Thank you. See, somebody was listening. Thank you. That is the date, the 4th. I wrote it. It was there before I started addressing your bond. God bless you.
Thank you, Your Honor.
It's good to see council's listening.
So Deirdre, your next date is gonna be on the 4th. I'll come and see you and give you all the information, okay?
Yes, thank
And
you.
the rest of us knew that before she did.
Thank you, Judge Simpson.
Thank you. Court does call the cases. People versus Jesse Ivy.
Ashley Phelps for the people and all six matters.
All 6 cases.
Assistant Public Defender, Carrie Ashton Ridley, Your Honor, on behalf of Mr. Jesse Ivy in all 6 matters as well. Mr. Ivy, state your name for the record, please.
Yes, young. Thank you.
Judge, we're asking for an adjournment in this matter. We're hoping to get a global resolution, and I'd also like to address bond.
But the global resolution includes more than these 6 cases.
Yes, Judge. I do believe there is a district court case as well.
Okay.
8 cases total right now.
Yeah.
8 open, including these 6.
Yes.
All right. So how much time would you need to try to get all that worked out? That was a question.
Yes.
Okay.
Yeah. I guess we can do
I have the 11th or the 18th?
let's do the 18th.
18th. Probable cause conference in these cases will be adjourned to December 18th, 2025, 9 a.m. Yes, as to bond.
As to bond, Your Honor, we are asking, I know that we do have low bonds on these cases. I think three of them. Three of them. So what?
You want me to let him out on all these retail frauds just in time for the holidays?
Well,
No, go ahead.
Judge.
Go ahead, make your argument.
Yes.
Judges use controlled sarcasm to test credibility. When a defendant has multiple open cases, timing suddenly matters. Holidays don't soften repeat conduct. They often make courts less patient.
Mr. Ivy he was in custody on three matters. He received a PR bond on those matters and he went over to Wayne County. And while he was in Wayne County, it's like deja vu. While he was in Wayne County, three more matters were authorized. So he completed,
Were they retail frauds?
yes, Your Honor.
Okay, all right. So that's 9. Go ahead.
Three more matters here were authorized. So that is why he's back here in Washtenaw. He was given a tether and a cash bond that was posted in Wayne County. And I know that the bond is not significant in these, but his family does not have the money to assist him with posting the bond. He reports that he is a father of 3 children. He has sole custody of his 5-year-old. So his elderly grandmother is actually helping him keep his 5-year-old right now while he's in custody. He reports that he is currently employed. He's hopeful that he'll be able to maintain his employment once he is released. He does have a good relationship with them.
He's employed?
Yes, Judge. He was prior to being arrested.
Okay, go ahead.
He was out of custody initially, and he was coming to his court dates. So the court should be able to see that his other hearings, he did appear. And then he was put in custody because he has a few cases that he's trying to keep up with, and went to the wrong courthouse in Wayne County. Once they realized the issue, they let him go, put him on a tether, but then by then, our new cases were authorized, and that's how he made his way over here.
Oh, you done? Okay.
So, Judge.
I can't wait for this. Response.
So, Your Honor, in 2021, the defendant was convicted of carrying a concealed weapon and sentenced to 1 to 5 years in the Department of Corrections. I can't tell for sure if he was on parole at the time of these, but it very well may have been, or very recently discharged from parole. I need that. In 2011, he was convicted of unarmed robbery, and in 2011, he also had another case for unarmed robbery where it looks like he got FIDA along with the 3rd-degree fleeing and eluding, and in 2006, he was, as a juvenile, adjudicated for a felony firearm case related to another robbery. Your Honor, I am asking the court to continue the bond as set, as most of these cases originate from the same location at Macy's, and they're high-degree retail frauds.
Anything else?
And Judge, we appreciate the information about Mr. Ivy's past, but he's been off of parole. I want to say that he's served his time.
Appreciate it.
It's
Okay, no, go ahead. I've never heard that before. But
it's been offered, so we
yeah, it was kind of flippant, but go ahead.
so Judge,
No, but I was listening.
as it pertains to these matters, Your Honor, he was on bond. He was coming to court as required in these cases. And the only reason he's got this new bond is because there were new cases that were authorized after the fact. So he's been compliant with his bond when he was out, but for his mistake in Wayne County, which was quickly resolved, he would have been able to come in and turn himself in and do an out of custody warrant recall on these cases once they were authorized. I think that Wayne County is going to put the tether on him. I don't think he's opposed to a tether if the court feels that that is necessary. These are nonviolent cases. I don't think that he poses a risk. And yes, it is the holidays, Judge.
So, but he has a violent past and a theft past. And as counsel indicates, he might have been on parole or probation when some of these offenses
No, he
occurred
reports that he was off, Judge,
off of.
parole for 2 years prior to these
All right.
cases.
So what I'm going to do in this case, though, is that I'm not going to change his bond. I'm going to deny the request for a bond reduction. Let's see if we can get all of these wrapped up or how, whatever's going to happen with them prior to his release.
Okay.
So bond is denied.
Not punishment for today alone, but for yesterday, last year, and the behavior courts believe is likely tomorrow. Once a judge sees a revolving door cycle, bond arguments lose weight fast.
The bond, motion for bond reduction.
Thank you, Your Honor.
Court does call the cases of the people versus Ryan Phelps.
Government vote for the people.
It's a podium, state your name to the record.
Ryan Phelps. Thank you.
Your Honor, I believe we have a resolution of these matters. They're going to be guilty pleas.
We get those to my staff before I go ahead.
Here, you need to sign these.
Mr. Gay has been in touch with me throughout the week, and I think on 3 different occasions, he has been in touch with me in order to reach today's resolution. I apologize, we weren't able to.
And I have gone over his rights with Mr. Phelps. He informs me he's not on probation or parole. And
I have a
that one's already signed. I don't know if we need a plea form in the 15th district matter, Your Honor.
well,
He's
this
pleading-
one is for the 15th district court.
Yeah, he's pleading guilty to count 2, which is the retail fraud on the complaint, and there's
I need a plea form because that's how they go through.
okay. Yeah, I did fill out a plea form. I just didn't know if the court needed it. That's for the 14B matter.
In the case ending in 1285, I have a plea form now that indicates that the defendant is going to be pleading guilty to counts 4 and 5. Count 4, malicious destruction, 200 to 1,000, the 1-year offense, and count 5, an assault and battery, 93-day offense. Upon a successful plea to that, charges counts 1, 2, and 3 would be dismissed. Defendant is also agreeing to pay restitution for all tires.
Yes, Your Honor, it's a tire slashing case.
He's going to pay restitution for all the tires. There is no sentencing agreement. That's court's full understanding in that case. In the other case, it's court's understanding that he's going to be pleading guilty to the stated count 2 of retail fraud in the 3rd degree, 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreements in these cases.
That's correct, Judge.
Let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Ryan Phelps.
Sir, it is this court's understanding you're going to be pleading guilty to 3 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
In the case ending in 1285, the Ypsilanti Township matters, you're going to be pleading guilty to an added count 4 of malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is otherwise destroyed or injured. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, Your Honor.
And also in that case, you'll be pleading guilty to the charge of assault and battery. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
In the other matter, the City of Ann Arbor matter, you'll be pleading guilty to the stated count 2 of retail fraud in the 3rd degree. That is indicated as a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
Sir, I do have to advise you that in the 14B or Ypsilanti Township matters, while I'm taking your plea, I would not be your sentencing judge. The sentencing judge waiver is not signed. Did you go over that with him?
Yes, Your Honor. I believe he signed, I had him sign both forms.
You understand that I would not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
In the other matter, likewise, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty
Yes, Your Honor.
to the charge of malicious destruction of property, 200 to 1,000. How do you plead?
Guilty.
To the charge of assault and battery, how do you plead?
Guilty.
To the charge of retail fraud in the 3rd degree, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind in this matter.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of these offenses?
Yes, sir.
Starting again with the Ypsilanti Township matter. Sir, on the date of August 28, 2025, at the location of 6261 Lake Drive in Ypsilanti Township, Washtenaw County, State of Michigan, what did you do on that date involving involving a Samuel Hasley that makes you think that you're guilty, Samuel or Austin Hasley, that makes you think that you're guilty of assault and battery? And what did you do regarding the property of Austin Hasley that makes you think that you're guilty?
As of right now, I can't quite remember, Your Honor.
Your Honor, I'd ask the court to adjourn this matter to Tuesday. So we
I'm
can,
not doing Tuesday. I will adjourn the matter to December 4th, 2025. 9 a.m. Thank you.
Thank
Bond
you, Judge.
continued. Court calls the case, People versus Raphael Starks.
Hannah, on behalf of Mr.
Oh.
Starks.
Oh.
I was here.
You decided to show up today.
You know,
Yeah. What do you mean he knows?
I was here at like late early.
Late early. What'd you say?
You told me the same thing.
Say she told you the same thing? You do believe it?
A little bit.
I don't.
I trust.
No, Yeah.
Your Honor, Mr.
that's your problem. No, not
He
you.
does. I got him. Sorry, excuse me. We're gonna waive.
He's waiving his right to a preliminary exam.
And Your Honor, when appropriate, I would like to address bond.
All right. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with counts 3, 5 following.
Your Honor, we would
waive the formal reading of the information. We stand mute as to the charges.
And in every way, form of reading, and the court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set for
December 1st at 1:30, Judge Moody.
December 1st, 2025, 1:30, before Judge Hamud.
And Your Honor, as to bond, my client, he understands the seriousness of this nature. He is asking for if you could amend the bond, by lowering it, to maybe a 5,000, 10%. He has been taking care of, the bonds, the holds that he has. He's gotten 2 PR bonds, I think. We know the Oakland County matter. We're trying to get him arraigned on that as well.
What are those other charges?
The OWI is out of Oakland. He has an OWI hold out of Oakland. But it is from 2021, Your Honor.
Okay.
And so he has a hold there. So he's taking care of the driving while license suspended, which just leaves him with the OWI, and we are working to see if we can get him arraigned on that as well. So we're asking for a low bond in this case, so he has the opportunity to bond out. He is the sole provider for his household, which includes his wife, mother, and daughter. His job, as he knows it, is still waiting for him. He just needs to get out to get back to work. He is willing to go on GPS tether. Any transportation will be handled either between his mom or his wife, so he won't be getting in a vehicle anytime soon. And Your Honor, we are hoping to resolve this well short of trial. He's just asking for the opportunity to be released.
Respond.
People would object. Obviously, this OWI of Troy has been pending for quite some time, and he wasn't resolving that. He was pulled over for a traffic violation in this matter. He had a suspended driver's license. The officer advised that he needed to be taken into custody to look into the hold for that Troy OWI. He instead put the car in drive, drove off, ran over the officer's foot, injured the officer. And to his credit, he did later turn himself in at Eastern Michigan Police Department. But in light of the fact that he has been, or at least that he has not resolved that case for several years, he ran over officers. In this case, to avoid that, people are concerned that he would not comply with the conditions of bond. And we've asked the court to deny the motion.
Your Honor, in talking to my client about what happened that day, when the officer reapproached, he had his hand on his gun, and my client, he freaked out. He didn't even realize the officer had been injured. As soon as he got home, he thought about what he did and he turned himself in. He didn't know about the injury. He is just asking if he could be, and again, I think GPS tether would accommodate, keep the public safe in this particular case and assure that he is appearing for court.
When he ran over the officer's foot, he obviously escaped the scene at that point.
That's correct.
Yes, he went home and probably within a couple hours, he turned himself right back. He turned himself in.
What I'm going to do in this matter is I will lower the defendant's bond. I'll give him the 10% provision on the bond of 20,000. I will not lower it where you want, but I'll give a 10% provision. But defendant must be released on I guess what I'm concerned about is whether or not there's a substance abuse or alcohol issue.
None, Your Honor. None of his charges. Oh, the OWI.
Why? That he never dealt with.
It has to be dealt with. No. You got to address it.
All right. So I'll reduce that, but defendant would be, so I'll reduce it to a 10%, but defendant must be put on a GPS tracking location tether prior to release.
Thank you, Your Honor.
Court does call the case People versus Christopher Walker.
People.
This is Public Defender Zach Vinue on behalf of Mr. Walker, who is present and approaching. Can you please state your name for the record?
Oh, Christopher Walker, Christopher Lawrence Walker.
Thank you.
Your Honor, we would request an adjournment. We are waiting on some discovery. We just got the police report yesterday. I believe we're still waiting on the media discovery, and then I would ask to address bond when appropriate.
Probable cause conference will be adjourned to December 4th, 2025, 9 a.m. Yes, as to bond.
Your Honor, so Mr. Walker has been in custody for 8 days now. He is fearful of losing his jobs. He has 2 jobs, Your Honor. He works at Molly's Cupcakes and Jolly Pumpkin. Are those both the downtown Ann Arbor
Yes, sir.
locations? Yes, sir. He is currently.
Jolly Pumpkin. Go ahead.
I believe there's one in like East Lansing as well, Your Honor. But so he's currently
that.
What'd you say? Your Honor?
East Lansing?
I don't know where that is either, Your Honor. I apologize.
Why would you even bring that? There's multiples?
Yeah.
Thank you for sharing. I didn't know of one. All right, anyway.
So, Your Honor, he's
Not mean for
currently.
this to go there, but
Yeah.
go ahead.
Your Honor, he is currently at risk of losing both of those jobs and being unable to support his children. He has 5 children, Your Honor, whom he supports financially. He is not a flight risk. He's lived in Washtenaw County on and off for the last 15 years, Your Honor. He's originally from Taylor. So we would be asking for home confinement with a GPS tether and the ability to travel to and from work. I can provide all the
Why
addresses.
is he in custody?
Your Honor, the charges are an R&O and then a misdemeanor assault and battery. Yeah.
I know what the charges are. Is anything else holding him?
No, Your Honor.
Response?
And people would object. In this case, police were looking for him because there was a report that he had assaulted a romantic partner, was kicking the windows at her home trying to get in. While he was walking down the street, it is alleged that he walked up to a gentleman and just punched him for no reason. That's the gentleman who called the police. That victim is the victim of the assault and battery. In this case, he maintained visual of the defendant as he went to the speedway. The police officers arrived. He pointed them out. The defendant then resisted being taken into custody. He fought with the officers. He was verbally abusive. And when the victim of the assault and battery was brought to identify him, he repeatedly said, "That's why you got punched in your shit." So this is a person who people have concerns about safety of the community, does have this criminal history, buildings 1,000 to 20,000, domestic violence, arrests, an attempt, assault with intent to do great bodily harm, or by strangulation.
Motion for bond reduction. I don't need any more. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor.
Thank you. Court calls the case of the people versus Devon, is it Galliard?
Ready, Your Honor. And good afternoon to you and your staff, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Galliard.
Ma'am or sir, where's your client?
My client is currently in Georgia. I'm ready to address everything on the record here today, Your Honor.
A tether is not a passport. Permission is location-specific, not lifestyle-based. The moment a defendant reframes court permission as personal freedom, credibility collapses and consequences accelerate.
Well, is he here?
He's
There
not
he
here.
is, right there.
Yeah, he's
I
on
see.
Zoom, Your Honor.
Sir, state your name.
Devon Galliard.
All right, why don't we address that? Because
But if I may, Your Honor. So evident from the information that defense has received and I've received, my client does and currently still does live in Texas, Your Honor. Again, he's never been in this situation before. That being said, he is monitored on a tether. I believe he, for lack of a better term, a misunderstanding where he was under the impression that since he's returning to Texas and is going to eventually move closer to Michigan being Georgia, that he was able to go there while being monitored. Again, I would just point out this is not an
But
excuse, reason.
counsel, no. He never went to Texas. He said, I watched the video when I got this, and he indicated he was going to Texas. There was nothing about Georgia, North Carolina, or any other thing. Nothing.
And I do understand that, Your Honor. My client's not sitting here trying to deceive you or the court, and he was very upfront and honest with the tether people when they asked, and he did talk to them with the tether company. He was not trying to hide anything. And I can completely understand the court's frustration with that. And I just would like to say that is not my client's intent. He does not have a history of skipping court, and the only reason I had him appear and as stated in court prior, if you do remember, but I know you deal with a lot of cases, so I wouldn't be surprised if you didn't. He was even willing to buy plane tickets to fly back and forth through the onset of this case. So I would just like this court to know, Your Honor, that my client is not trying to avoid anything and avoid you or the court or this case in any way, shape, or form, Your Honor, or disobey you for that matter.
That's not courtroom drama. That's raw judicial authority. A bench warrant flips the power dynamic instantly, from voluntary return to forced retrieval. And once those words are spoken, the system no longer waits, it moves.
Ms. Zenda.
Your Honor, I have concerns given that, one, he was not permitted to appear on Zoom today. That was revoked given this report. I also have concerns given that the representations that were made was that he was going to be living in Texas. He never goes to Texas, starts residing somewhere else, and he doesn't come back for this hearing that he was supposed to be in person for today. He's facing very serious charges. I have concerns that he's just out and about across the country. I originally wasn't comfortable with him even going to Texas, and I'm even more uncomfortable with the arrangement.
So, and I have a problem, counsel, when, as indicated in the community corrections report, he told them that he was permitted to travel to Texas to get his things and that he could stay in Georgia. That was never talked about, not at all. And outside of the fact that even if it was, he's not just in Texas, he's in South Carolina, North Carolina. He's all over the southern eastern seaboard, with the exception of Florida. At least we don't have him there. And he's just going about his own, doing whatever he wants to do. And Ms. Senda's right. Once we get this, his permission to appear via Zoom was revoked. He needed to be here in person. He is not here.
Yes. If I can speak for myself, I'm sorry, Your Honor. I was just, the reason why I didn't because I did my household goods virtually, and they was gonna send my stuff here. So I wanted to save money and stay here in Georgia.
You don't have the permission of the court to be in Georgia.
That's my apologies. I wasn't tracking that. I was trying to make it easier so I can be closer here to, if I need to go to court, I could be here with my mother and I could just go from here to Michigan. Because I did, when you said that, as long as I'm on this tether, I can go anywhere I need to go. As long as I don't go anywhere near Texas. No, you did say that. You did say that.
No, Mr. Gallier, I'm gonna, and Your Honor, if I may, I don't mean to interrupt you. But
go ahead.
I've talked with my client. My client is taking full responsibility. I have talked to him about this today. He completely understands the frustration with the court, and that just because you're given permission to travel does not mean you can go wherever you want. He is understanding of that, Your Honor. I assure you that. And
but he's representing that I told him something I didn't say. He's representing that to our community corrections. I'm not having it. When I let people travel, I let people go where they want to go. the circumstances were given to this court. He said he lives in Texas. He wanted to go to Texas. I was going to allow him to reside in Texas. Come to find out, he never went to Texas. He's somewhere else, a few thousand miles from Texas, and just is there and trying to give me some excuse. I'm not having it. He needs to get himself back to the state of Michigan. If he doesn't want to get himself back to the state of Michigan, we will come and get him. A bench warrant's going to issue for the defendant's failure to appear. No bond. So you better get here before we get to you. I'm done.
And Your Honor, my client can turn himself in at any point. We can readdress this when he comes back.
We will be
he will
more
back
than
very
happy
shortly.
to take him.
Okay,
Thank
Your
you.
Honor. I will speak with my client and arrange his return, Your Honor.
Court does call the case. People versus Dwight Miller.
People.
Good afternoon, Your Honor. Rob J. Kilwald calling outside of Judge Slay's courtroom. Good afternoon, Your Honor. Dwight, would you state your name for the record?
I'm American State National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. All my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the record.
Okay, first of all, I'm going to stop this. I directed this defendant to be in this courthouse in person.
I got a bad back, sir.
And he is not here in person.
Sir, I
am not going to sit here and listen to him ramble on and on about everything.
Oh, really?
I don't
So
mind
you
hearing
violate
from
my
people, but I
constitutional
tell
rights?
you, if you're
You
going to
gonna
say
violate
it
my
all, you're going to
constitutional
say it to my face. Bench
You gonna
warrant will
violate
issue
my
for defendant's
constitutional
failure
rights?
to appear. No
I
bond.
am here.
We'll get him
I can't-
here.
I got a
Thank
medical
you.
issue.
You
So
can
you gonna
mute
violate
him.
my
Thank you, Mr. Kilowald.
Okay, Judge. Thank you. Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr.
Right.
Court does call the case. People versus Gary Coward.
Good afternoon, Your Honor.
Hey, Simpson, I'm coming to see you, bro. You violated my constitutional rights. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems. Get that number. Yeah, I bet you it did log out. Get that number. It will have the full number. We'll go find him. Get the detective bureau on that, please. All right, let's go. You don't want to come up here now, do you? I know. He's just standing there like, man, I just, oh, my name, I'm just up
Do you
here.
want me to contact the detective bureau for you?
Pardon?
Do you want me to reach out to the DB?
I think he is.
Okay, yeah. Got it.
Your name, sir?
Gary Coward.
And who's representing Mr. Coward? Mr. Burgess?
I am. Sorry, Your Honor. Good morning. Good afternoon. May it please the Honorable Court, David Burgess on behalf of Gary Coward. I'm appearing via Zoom, Judge, because it seems a little scary in your courtroom today. So.
Wow. I'm calm.
My client is present, Your Honor. He's raising no constitutional issues, and he is a citizen of the United States.
Thank you.
I'm done, Your Honor. Sorry.
No, you're not. You are just getting started. What are we doing on this case?
Judge, we're still trying to, Mr. Banis and I were still trying to resolve the matter at the district court level. So I'm still discussing it with him. We're just asking for a couple weeks adjournment of the PCC.
Will the 11th work for you? I think you're here anyway on the 11th. I think
so.
For you.
Yes, Your Honor.
All right. Will that work for you?
Yes, sir. Can I appear at Zoom, please?
Pardon?
Can I appear at Zoom at all?
That hasn't worked out for people today. No.
He's messing with you.
If you submit talk to your attorney, there's paperwork that needs to be submitted before that can be approved.
Okay, thank you.
Okay.
Thank you, Your Honor.
December 11th, 2025, 9 a.m.
All right, thank you.
Bond will continue. Thank you, Mr. Coward. Appreciate your patience, sir.